All right, so recall that on Monday of this week, Mark Meadows took the stand and testified under oath during his hearing to have his criminal case removed from state court in Fulton County, Georgia, to federal court, where he's got, the possibility of getting a Trump-appointed judge and a much better opportunity of picking a jury that would be more favorable to him. So he testified under oath, and basically he testified that every single thing that he did following Election Day in 2020 until Inauguration Day was within the scope of his job duties as White House Chief of Staff. That by definition, there was nothing that he could do that would not be within the scope of his job duties as White House Chief of Staff. I mean, the argument he was making basically is the argument that Nixon made. If the president does it, then it's not illegal. It's circular. It's conclusory. It's a conclusory argument. It's just silly. It's a silly argument. And so, but Tuesday morning, the judge issued a question to the attorneys in the case, wanting some more information. And that question was, would a finding, well, let me back up for 1 second. So Fani Willis charged like 120, 130 overt acts within the indictment by various people. Those acts, when viewed in their entirety, were all in furtherance of the RICO conspiracy. And that's what you got to do to charge a RICO case. Those acts individually might not be illegal in and of themselves, but when viewed in its entirety, you're acting to advance the conspiracy, the illegal goals. And so the question the judge asked is, would a finding that at least one, but not all, of the overt acts charged against Meadows occurred under the color of Meadows' office within the scope of his employment be sufficient for federal removal of a criminal prosecution? Meaning, if the judge finds that at least one of the acts that's in the indictment that's attributed to Mark Meadows was within the scope of his employment, is that enough for him to remove the case from state court into federal court? Fani Willis obviously says no. And I have her briefing that she submitted at 5 p.m. today. So the first section, the defendant's prosecution commenced not from any individual overt act, but from his entry into the conspiracy. So she's arguing, yeah, he did all of these individual acts, but the one that matters is his act, his decision to enter into this unlawful conspiracy, and the fact that he did enter into an unlawful conspiracy that negates a lot of other things, in her view. The defendant is charged in count 1 with agreeing to join a conspiracy that planned to overturn the lawful results of an election in Georgia. Good writing in this brief, I gotta say. An examination of RICO and conspiracy law more generally illustrates the crucial difference between a single overt act and the joining of a conspiracy. And then she gives some background. The question posed by this court contemplates a finding that the defendant has committed at least one overt act outside the color of his office. This would be more than what is required to demonstrate the defendant's participation in a RICO conspiracy. And then she goes on to state that under the Georgia RICO law, if he enters into the conspiracy with other people, he's not required to commit an overt act in furtherance of the conspiracy. If other co-defendants commit at least 2 overt acts, those acts are attributable to him, meaning he gets tagged for them too. So that's broader than federal, than federal RICO. It is well settled that when individuals associate themselves in an unlawful enterprise, any act done in pursuance of the conspiracy by one or more of the conspirators is in legal contemplation the act of all. Meaning, if one guy acts, it's the same as all of them acting. So then she goes into, the indictment alleges that the defendant conspired to violate the Georgia RICO statute and the state of Georgia has submitted evidence substantiating that allegation. And she talks about his participation in that phone call between Trump and Brad Raffensperger. He didn't just listen. He participated in that call, and he got argumentative with Brad Raffensperger a couple of times and berated him over the issue of dead voters. And Brad Raffensperger said, no, the number was like 2. And Meadows is like, I can promise you that there were more than that. And this is one of my favorite lines. And after insisting that he did not play any role in the coordination of slates of fake electors throughout the several states, the defendant was forced to acknowledge under cross-examination that he had in fact given direction to a campaign official in this regard. And then he got cross-examined with a bunch of emails between him and I think it was Jason Miller, and he was forwarding memos to Jason Miller that had been written by Kenneth Chesebro, also co-defendant. He goes to trial at the end of October. The defendant has not disputed his participation in any of these events. He's not disputing any of the facts in the indictment. He simply argues that all of them were within the scope of his duties and occurred under the color of his office. A finding that some of the overt acts attributed to the defendant occurred under color of office, it would not suffice to show that the defendant's joining the conspiracy was itself within the scope of his employment or even related to his employment. So she makes some really strong arguments here. Then she does something else. In the second section, she goes beyond what the judge has asked, and she tries to circumvent one of Mark Meadows' anticipated defenses, which is smart because you always got to go above and beyond to make the judge's job easy. If you're asking the judge to do something, reject their motion, you give the judge everything they need in your motion or your pleading to make it easy for the judge to give you what you want. So the judge asked one question, she answered that question, and then she went above and beyond that. It's like, here's an anticipated defense that he's going to bring up, and this is why you should ignore it. He's already claimed the Supremacy Clause. He's already claimed First Amendment stuff. But Supremacy Clause has to be a defense to everything, not just a little bit. And so you can't cut up these overt acts and say, well, these fit with Supremacy Clause, but these ones don't. And First Amendment, that's so easily shot down. Nobody has a First Amendment right to join a RICO conspiracy. So she did a really good job shooting those down. And so then she quotes, so Meadows had filed a motion to dismiss, and she quotes that in here by saying they've completely ignored the Hatch Act in all of these arguments relative to his motion to move the case from state court to federal court. And she quotes his motion to dismiss. All of the alleged conduct as to Mr. Meadows relates to protected political activity and lies in the heartland of the First Amendment, and all of the substantive allegations in the indictment concern unquestionably political activity. That's what the Hatch Act is preventing. And thus, if not covered by the Supremacy Clause immunity, the charges would be barred by the First Amendment. They're completely ignoring that the Hatch Act even exists. They're just ignoring it. And that, I think, is going to do them in on this. Now, the part where Meadows got busted on cross-examination and had to admit that he did participate in the slates of fake electors with political people from the campaign, I think that presents him with a perjury problem. And at a minimum, it discredits him with the judge. And when you lie on the stand, the judge can disregard your testimony as to that particular item or disregard your testimony in its entirety. It's up to the judge. It's totally up to him. So I don't think this judge is going to find that Mark Meadows has much credibility at all. And I think this case is going to stay in state court where it should, where it will be televised.